Well, good morning. I'm Jagender Rana. The topic for our discussion today is freight services legal liability insurance. Freight services legal liability insurance. This is a special type of policy being basically underwritten by the miscellaneous department of the insurance company. And this policy indemnifies in consideration of and subject to the payment of the premium as per the agreement of the insured to pay the deductible amount that is policy excess stated in the policy schedule and described in relation upon the particulars, statements, representations, attachments and exhibits contained in the and submitted with the application, which is the basis of the policy. Policy affords that the company will pay on behalf of the insured and sums in excess of the deductible amount stated in the policy schedule, which the insured shall become legally liable to pay. So the physical loss of or damage to the goods, parcels not belonging to the insured, but while it held in trust or in care and custody or in the control of the insured or his employees or subcontractors in the capacity of the logistic services providers within territorial limits specified in the policy schedule as a result of the wrongful act by the insured and with the wrongful act resulting in the realization of the risk specified. This could be fire damage, implosion damage, aircraft or aerials or space devices and articles dropped therefrom, then joint strike malicious damage subject to the clause attached, burglary or housebreaking or loss damage, impact damage by any rail, road, vehicle or animal, accidental damage, fresh water and rainwater damage, theft and privilege loss following tampering or package of goods, and proven non-delivery. Provided that such wrongful act was committed on or after the retroactive date and before the end of the policy period. So, certain things has to be clarified here. Territory defense, consents and settlement. Because the company has the sole right to appoint defense counsel and the right but not the duty to defend any claim made against the insured. If the company does not exercise this right, the insured under the supervision of the company and only with the prior consent shall make or have made such investigations and defense as may be reasonably necessary. And cooperation. The insured shall cooperate with the company upon the company's request and submit to examination and interrogation by a representative of the company under oath if required, shall securing and giving evidence, obtaining the attendance of the witnesses in the conduct of suits as well as in giving a written statement or statements of the company's representative and meeting with the representatives for the purpose of investigation. Everything is defined here, like claims. Claims means received by the insured of a demand naming the insured and seeking damages or injunctive or declaratory relief arising out of the wrongful act by the insured. Claims expenses means reasonable and necessary fees charged by the attorney designated by the company to defend a claim. Damages means any compensatory sum which an insured is legally obliged to pay for the claim to which this insurance applies and shall include judgments and settlements with the company's written consent, provided always that damages shall not include fines or penalties or punitive damages awarded or levied directly against the insured imposed by law or otherwise, nor the return of or restitution of the fees or charges or services rendered. Here the insured means only the following: the named insured designated in the item number of the policy schedule or by endorsement to this policy. If during the policy period the named insured acquires or creates another entity other than a joint venture, such entity shall be considered an insured under this policy, but only for wrongful acts committed after the date of acquisition or creation. Then policy period means the period set forth in item number of the policy or any other shorter period that may occur as a result of a cancellation of this policy, and specifically excludes any extended reporting period. Pollutant means any solid, liquid, gaseous or thermal, irritant or contaminant, including without limitation smoke, vapor, soot, fumes, acids, alkalis, chemicals, lead, oil or oil products, radiations, asbestos. So waste include but is not limited to material to be recycled or reconditioned or reclaimed. Retroactive date means the date specified in item number. This policy shall only apply to claims resulting from wrongful act committed on or after that date. Policy excludes the losses and does not apply to pay for based upon or arising from any deliberate or dishonest or malicious or fraudulent act or omission or any willful violations of law by the insured, by or on behalf of or with the assistance of any insured. Entry which at the time of the wrongful act or at the time of the claim or during pendency of the claim is or was affiliated with any insured through any common owner, ownership or control, or acting with the insured as a director, officer, partner or principal stakeholder. So as far as notice is concerned, in the event of a claim, the insured shall, as a condition precedent to the coverage offered by this policy, immediately forward to the company every demand, notice, summon or other process, including institutions or arbitration proceedings received by the insured. Deductibles: the company shall only be liable for those amounts payable for damages or claims expenses which are in excess of the deductibles. These deductibles shall apply separately to each claim and shall be borne by the insured. and remain uninsured for the purpose of the deductibles. Claims arising out of the same wrongful act shall be considered one claim, and only one deductible amount shall apply. If there is any other insurance, if any claim or wrongful act noticed to the company under this policy is insured by another valid policy or policies, then this policy shall apply only in excess of the amount of any deductibles, retentions, and limits of liability under such other policy or policy. Subrogation: in the event of any payment under this policy, the company shall be subrogated to all of the insured's rights or recoveries against any person or organization, and the insured shall execute and deliver instruments and papers and do whatever else is necessary to preserve and secure such rights. Alteration and assignment: no change in modification of or assignment of interest under this policy shall be effective except when made by written endorsement signed by an authorized representatives of the company. As far as notice of cancellation is concerned, the policy may be cancelled at any time by 15 days notice by registered letter from the company to the company's last known address, and in such event the company will return a pro rata portion of the premium for the unexpired part of the insurance. This policy may also be cancelled by the insured by giving 15 days notice in writing to the company, in which event the company shall cancel the policy and refund the premium in short period basis, subject to no claim under the policy during period of insurance. Thank you very much.